Oh,
We're now recording. Thanks.
Okay. So we start the session between AIPLA and LES. So the opening remarks should from AIPLA side.
Yeah, Mr. Patrick Coyne, who is president-elect of AIPLA, is on deck to speak. You're just on mute right now. Okay, good.
Hello. Good
Hello.
evening. We have a long history of these meetings in April. It's unfortunate again that we're not able to meet face to face. We enjoy these encounters a great deal because of an interesting exchange of ideas and an opportunity to get together with you and get to know each other better. A lot of delegates at prior to these meetings have talked about everybody's hospitality when we have been able to get together, and we're looking very much forward to being able to do that soon. We're very hopeful that things will start opening up in the latter part of this year, and hopefully that we can get together in person, live in 2022. But we do enjoy, as Neil said, these virtual meetings in the interim. It's a way to stay connected, a way to stay engaged, and continue to share ideas. And we're also very much looking forward to the networking sessions following the information exchange. So thank you very much for everybody in attending, and welcome, and enjoy the program.
Thank you very much. So now that I would like to introduce Mr. Hiroki Saito, the president of LES Japan, for opening remarks.
Hi, good evening to those in the US, and good morning to LES Japan members. I'm Hiroki Saito, current president of LES Japan. And I'm a practicing attorney with the law firm Morihamada and Matsumoto. And again, it is unfortunate that we could not have this great joint meeting last year, but I'm very much pleased that we can have although online, this joint meeting this year. This is great opportunity to know each side's development in IP field, and also fasten our friendship. And even during this pandemic time, the innovation is continuing, and the importance of IP is unchanged. And we are still battling against these COVID viruses, but I hope we can overcome this situation, and we can meet in real situation next year. And I'm looking forward to hearing from 4 speakers the recent developments in both countries. Thank you very much.
Thank you, Saito-san. So, shall we move to the first session?
Yeah, I think we're ready to move ahead. And the first speaker will be John Johnson from the AIPLA side. John is with Fish and Richardson, and is actually coming to us today from California. So he's a little bit earlier than those of us on the East Coast. And John, you've got your screen up there. That's great. I'll turn it over to you. Thank you.
Okay, good morning, everybody. Thanks, Neil. Grateful that I can have this opportunity to present to our friends at LES Japan, a longstanding member of the AIPLA IP practice in Japan committee. And it is unfortunate that we're unable to see each other, but I'm glad that we can get together on this Zoom video conference. So today I am going to be talking about a pending Supreme Court case. It's the Hologic versus Minerva case, and it deals with the issue of assigner estoppel, which is a judge-made doctrine in the United States that bars a patent assigner from later challenging patent validity in an infringement lawsuit. So let's say an inventor assigns his application or patent to a company, and that inventor starts a competing company later, is then charged with infringement of the assigned patent by the owner of the patent. That new company is, under the current law, we say, stopped from challenging validity. In other words, the assigner is prevented from challenging validity. So that's what the Supreme Court is addressing. And I just want to ask the question of how come, why would that estoppel apply? And it's because the inventor assigned the patent and got a benefit from that assignment. It wouldn't be fair, it wouldn't be equitable if the inventor could start a new company, infringe the patent, and at the same time challenge the validity of the patent. All right, so as I mentioned, assigner estoppel is an equitable doctrine, and it bars the assigner from challenging patent validity. And again, the Supreme Court is addressing whether that ability to challenge patent validity should be permitted, whether the person who has assigned away the patent should be allowed to challenge validity in a later lawsuit. This, as I mentioned, is a court-made doctrine. It is not found in any statute in the United States. I will say that assigner estoppel is rare in US litigation. I think if you ask many of the attorneys on the US side who litigate, that it is very rare. I have seen it in one case in my career. And as a defendant, it was quite a scary situation because I think you just don't really see it very often. Now, there is a related doctrine that I want to mention, and it is called licensor estoppel. And that in 1969, the Supreme Court abolished what is known as licensor estoppel in a case called Lear v. Atkins. And the Supreme Court held that a licensee was not stopped from challenging the validity of a patent after he had licensed the patent. The Supreme Court in that case talked about the public interest in permitting full and free competition in the use of ideas. And after the Supreme Court killed licensee estoppel in 1969, many US courts in the United States questioned whether the doctrine of assigner estoppel also remained alive. But in 1988, the Federal Circuit spoke, and the Federal Circuit found that the doctrine of assigner estoppel was very much alive. So let's move on to this slide here, slide 5, and you can see this is a picture of the US Supreme Court. You can see the cherry trees in the front blossoming, and I understand that it's quite beautiful right now with these cherry trees in DC. We're actually at a timely moment because this case, the Minerva versus Hologic case, was set for oral argument today. And so this morning, the Supreme Court heard oral argument in this case, and for about an hour and 15 minutes, argument took place. And I actually put a little link here so we could listen to it, but given that we only have a few minutes, I'm going to pass on trying to do that, listening to at least part of it. So I want to give you some factual background so you can understand what the Supreme Court is addressing. In 1993, Mr. Saba Trakai, Mr. Trakai, he founded a company called Novacept. And after he started that company, Mr. Trakai was named as a co-inventor on a number of patent applications, including 2 US patent applications at issue in this case. Those 2 patent applications were assigned to Novacept. And then in 2004, a company called Cytec acquired Novacept for $325 million. And of course, the applications, the patent applications were part of the sale. Now, Mr. Truckeye, it is reported, received $8 million for the sale of Novocept to Cytec. About a year later, the 183 patent issued, and that's a patent that's going to be relevant to the dispute in this case. 2 years later, Hologic acquires Cytec. And a year after that, in 2008, Mr. Truckeye starts a company called Minerva Surgical. Several years later, actually about 7 years later, the second patent, the 348 patent, issues. And these two patents that issued, the 183 and the 348, those are related to the two applications that Mr. Truckeye was named as a co-inventor on after he founded Novocept. Later in the year, in 2015, Hologic sued Minerva in Delaware for patent infringement. And Hologic, as you can imagine, asserted infringement of those two patents, the 183 and the 348. Now, Minerva, as is typical in often the case in U.S. litigation, Minerva filed IPRs on both of the 183 and the 348. Now, on the 183, the PTAB found the claims invalid, and on the other patent, the 348, the PTAB denied IPR institution. So Hologic filed a motion to the judge for summary judgment asking that the court hold that assigner estoppel bars the invalidity defense and that the patents have been infringed. Now, Minerva, the defendant, filed for summary judgment saying that the 183 patent has been found invalid by the PTAB. The court in Delaware, you can see on slide 9, concluded and held that assigner estoppel is still alive and bars invalidity, and observed that Mr. Truckeye invented and assigned the applications, and that the balance of equities here strongly favor assigner estoppel. Mr. Truckeye was in privity, meaning he was in the chain of the corporate transfers from the start until the finish. He founded this defendant company, Minerva. He helped develop the product that being accused of infringement. He tested it and he made it, helped make it. And he also had an executive leadership role at Minerva. Now, the judge also concluded that the 183 and the 348 patents were infringed, and denied Minerva's motion that the 183 patent is invalid because of the IPR, concluding that that actual IPR was on appeal to the Federal Circuit. Now, importantly, the Federal Circuit later, in a separate decision, affirmed the PTAB invalidity, and then the judge actually applied that ruling to deny an injunction and damages. So in 2020, this case gets up to a 3-judge panel of the Federal Circuit. And the Federal Circuit affirmed the application of assigner estoppel. And the Federal Circuit pointed to some earlier Supreme Court cases, namely the Westinghouse case in 1924 and Scott Paper in 1945. And while those cases found some exceptions to the doctrine of assigner estoppel, they did not eliminate it. The Federal Circuit spoke about various policy issues and the tensions and the conflicts that exist with respect to this doctrine, and we'll talk about those issues in a moment. The Federal Circuit also found that assigner estoppel does not preclude Minerva from relying on the PTAB's invalidity decision on the 183 patent. Remember, I said that the Federal Circuit in a separate decision also affirmed invalidity. So the Federal Circuit said that essentially assigner estoppel does not reach that IPR challenge because the America Invents Act concluded that a person who is not an owner can file an IPR. So the doctrine of assigner estoppel did not apply to the Patent Office proceedings. Now, one judge on the panel, Judge Stoll, wrote some additional views about this issue. And, you know, Judge Stoll observed that what the decision demonstrated was a peculiar circumstance in that it presents an odd situation where an assigner can circumvent the doctrine of assigner estoppel by attacking the validity of a patent claim in the Patent Office, but cannot do the same in the district court. So she raised, for example, whether assigner estoppel should apply in the district court, but not apply in connection with IPR proceedings. So slide 12, this kind of just demonstrates the peculiar circumstance. And you can see for the 183 patent, the doctrine of assigner estoppel did not apply, but as to the 348 patent, the doctrine of assigner estoppel did apply, depending on success at the Patent Office. So let's get to the Supreme Court case. The questions are really, you know, two questions were presented, but, you know, let's just frame it this way. Minerva, who was the defendant, wants to kill assigner estoppel, right? Minerva doesn't want to be barred from challenging validity. Hologic wants to keep assigner estoppel, okay? Hologic wants to bar invalidity challenges as the plaintiff. That's what its goal is. So Minerva argued that, you know, the Patent Act, 35 USC section 282 says invalidity shall be available as a defense in any action asserting patent infringement. And that Congress permits this adversarial testing of validity in litigation, and that the Supreme Court has repeatedly rejected the Federal Circuit's attempt to read equitable, non-textual limitations into the Patent Act. And Minerva also argued that, you know, the doctrine, it should be allowed to challenge bad patents that are a drag to the economy. All right, so the defendant should be allowed to challenge those bad patents, and that the doctrine of assigner estoppel just imposes a tax on inventors. It's a tax on employees being mobile. It's a tax on startup enterprises. And in essence, it's really a covenant not to compete. Now, Hologic, on the other hand, again, Hologic being the plaintiff, wants to keep assigner estoppel as is. Says assigner estoppel has been in our law for 150 years. And the Supreme Court found Congress concluded that the doctrine should be part of the statute and is well settled, and that no one intended to reverse the Supreme Court's early Westinghouse decision. Hologic argued that many courts have applied assigner estoppel, and even the Federal Circuit in many cases has adopted it. Furthermore, Congress adopted it through the 1952 Patent Act, and even in the American Invents Act in 2011, it essentially was adopted because there was no objection to it. Hologic says that it promotes innovation to have assigner estoppel. It's a good thing that you know, you honor dealings in contracts and assignments, and that parties can always contract around assigner estoppel. Now, in these Supreme Court cases, there are what are known as amicus briefs that are filed. And the United States filed its own brief, and the Supreme Court actually allowed the United States to appear at argument and make its argument today. And the United States position was that it should be kept. Assigner estoppel is a basic principle that is a sound one, and that parties shouldn't be allowed to profit from contracting their earlier actions, representations, and that there's no reason to abolish assigner estoppel altogether. Now, the United States also said that there is, you know, strong policy that should not allow it to get too broad, though, assigner estoppel, and they provided kind of a narrower test for its application. We don't have time to go through that, but they wanted to kind of put some limit on the application of assigner estoppel, the United States' position. AIPLA also filed an amicus brief, and they followed in step with the United States, the government position that it should be kept, but that it should be kept narrow. And you can see here, it should be inapplicable where the assigner could not have known of the patent rights being asserted, such as claims asserted that bear little resemblance to the claims assigned, patent issues well after the assignment without any inventor input or assistance. And interestingly, during the Supreme Court argument today, counsel for one of the parties actually referred to the AIPLA amicus brief. So as I mentioned this morning, oral argument took place. That's an empty courtroom. The court had announced that the argument would be held telephonically. You were able to listen to it, and you can still actually access it and hear the arguments. It's about an hour and 15 minutes. I pulled up a photograph of the current justices of the United States Supreme Court. The Chief Justice, Justice Roberts, kind of guided the argument and assigned, based on the their length at the court, the ability to ask questions. And I'd say that a lot of questions were asked. Every single judge had many questions for both parties. I think the takeaway that I would say is that the justices seemed to be shy in abolishing or killing assigner estoppel. My thought is that they were kind of hesitant to upend longstanding law. So, for example, Justice Sotomayor down there on the right said, "Why should we interfere when this type of defense has been approved for such a long period of time?" That's one of the questions she asked. Justice Kavanaugh in the middle there said, "Why get involved in overturning something that was well settled as of 1924?" Another takeaway, I think the justices were very interested about some kind of a middle ground, suggesting that they're interested in finding a way to, keep the doctrine but limit it rather than abolish it. The attorney for the U.S. government was probed with many questions about, the government's proposal to keep it but kind of limit it. So there's no set date on when the Supreme Court has to issue its decision in this case. But I think with this term, we should expect that a decision will be rendered by the end of June. The last slide was, what are the predictions and thoughts? Maybe I should have brought this up earlier. Kill it like licensor estoppel, keep it without modification, keep it with some clarification. And I would say that my prediction is that the third bullet, it will be kept, and the Supreme Court will probably provide some guidance on how it should be applied in the future. And so I think that's about the amount of time I have. I wanted to send it back to Neil and see how we go about questions or whether we defer those until later.
Thanks very much, John. Really interesting presentation. Thank you. We are going to take questions now. We've got about 5 minutes for questions. So if you do have a question, you can put it in the chat area. And Todd is well off the mark. He's already got one in there, so that's good. And so the question from Todd is, in your experience, is it common practice for an assignment to preclude the assigner from subsequently challenging the validity of the subject patent? So I guess that means sort of in the past, was it allowed in district court?
You mean in the actual assignment document itself?
Oh, sorry, yes, yes.
I mean, I don't believe so that, you know, it certainly in my practice was not common to include in the assignment itself preclusion from subsequently challenging the validity of the patent. There's been some suggestion in the briefs that, you know, when doing assignments in the future, you know, this sort of clause may be advisable.
Yeah, we'll likely see it in all assignments now. Do you think that'll be effective?
You know, it's a question that was raised before the justices this morning, is whether it would be effective, and there was a big back and forth on whether, you know, such provisions in assignment documents will be effective. There was talk about, for example, you know, this notion of a covenant not to compete and things. I mean, I think it should be effective. That's my view. But I think there's some issues as to the legality of certain language that would be placed in these assignments.
Yeah, that'll be a whole new court case down the road sometime. Yeah, I was thinking it sounds to me like if the Supreme Court goes the way of the AIPLA, that it might be that the rule stays, but it's very fact specific. Do you think that's a likelihood?
Yeah, I thought, I mean, I think it is very fact specific, right? Because in this particular case, the inventor, you know, reaped a very big benefit, right? $8 million. And there is some, you know, sense of fairness that the inventor should not be able to challenge validity after receiving such a large sum. There was a discussion about whether assigner estoppel should apply when, you know, you're in a big company and you have these automatic assignments and, you know, there's not a big payoff. So Mr. Truck Guy received $8 million. That's a pretty massive payoff. He then later on started a competing company, and you know, he then developed a product that was infringing, right? So what about like at a very large company where you have thousands of inventors, and the inventors automatically assign off to the company, and then that, you know, inventor goes off and works for a different company, you know, does assigner estoppel apply there? I think that's an area that, you know, requires factual consideration and will have an impact on the conclusion made. I do think one other interesting thing about the argument today is there really wasn't a lot of discussion about, you know, assigner estoppel as it pertains to PTAB proceedings. You know, my take is that the parties have, you know, have concluded that you can file an IPR, and that's not going to be subject to assigner estoppel. One of the justices did raise that unusual situation, but it seemed like everyone kind of kept away from it. I out of interest went to the government's brief, and I was looking at the government's brief the other day to see if they had any discussion of that issue, and they didn't really touch that either. So
Yeah,
I think that, you know, filing, you can still file IPRs and avoid assigner estoppel.
Yeah, it's going to give you that additional track to be able to get around it. Yes. Well, I don't see any other questions. Does anybody want to jump in? If you have a question, you can unmute your mic and ask. Otherwise, we'll keep things rolling. Okay, thanks very much, John, for a great presentation. And we're doing well on time, so that's awesome. Tomoko-san, over to you.
Yes. Yeah, it's perfect timing, this John. Thank you for your interesting presentation. That is really informative. So the next speaker that I would like to introduce, Mr. Shuichi Endo, currently the president and CEO of Aldage Incorporation, a company established in 2006 to manage and operate the patent pool licensing programs for Japanese digital television standards. So Mr. Endo has 37 years experience in IPR licensing, including individual licenses. And that he started his career at JVC, at the Victor Company of Japan Ltd., and mainly involved in worldwide licensing activities for VHS video standards developed by JVC itself. And he then had worked for Thomson Licensing, and now that this company is known as Technicolor, now InterDigital, to support its licensing activities in Japan. Then I hope that I can hear the very interesting presentation from Mr. Endo. So turn it over to you, Mr. Endo.
Thank you, Noguchi-san, and good afternoon and good evening for the members from AIPLA, and good morning for the members from LES Japan. It's a great honor to me to speak at this AIPLA-LES Japan joint meeting. Today, I'd like to speak about the license for services. As Mr. Noguchi-san kindly introduced, I'm Shuichi Endo of Aldage Inc. So here you can find today's subjects. First, I'd like to introduce our company, Aldage Inc. and its activities, and then move to the DTV patent pool in Japan. And next, license for services for broadcasting, and a license for services for IoT, and conclusion. So first, I'd like to introduce our company, Aldage Inc. and its activities. The company name Aldage comes from the initial letter of the United License for Digital Age. The company was established in 2006. So in this year, we would have the 15th anniversary. The following 7 companies are our shareholders, which owns equal share to keep our company neutral. So I'd like to explain the background of the establishment of our company. So early 2000s, TV broadcasting was in the transition from analog to digital in Japan. And it's necessary to solve the standard essential patent issue, SEP issues, for the promotion of the standardized technology and relevant market. Under the circumstances, the owners of SEPs, consisting of the major consumer electronics manufacturers and NHK. NHK is the Japanese public broadcasting entity, and they own the substantial numbers of the valuable essential patents because they joined the standardization and discussed the possible solution of the SEP issue for Japanese DTV, and reached a conclusion to establish the Aldage as a license agent and solve that issue through the patent pool system. So next, here you can find the Aldage's philosophy. First, the promoting the SEP licensing for DTV in Japan under the fund conditions, and for the benefit of the patent holders and the potential licensees through the patent pool scheme. And the second one, this is unique, I think. Not only the receiving device, but the broadcasting services are licensed in order to keep the fairness of the implementers of the patents. We maintain these two as our philosophy. Let me introduce our activities. We have the following 4 license programs. 2K Live DTV for terrestrial and BSCS satellite, and 2K CATV for cable TV, and the ultra high definition version, 4K satellite UHD TV and 4K CATV UHD TV. So this is a copy of our official website, and I'd like to explain current status of our licensing programs based upon the 2 programs shown in red circles. Arrive 2K Essential Patent License and Satellite UHD TV 4K 8K Essential Patent License. As of April 1st, 2021, as with the 2K Arrive DTV, we have 19 licensors, including 1 from the United States, 2 from France, and 1 from Korea. We have 336 licensees, including broadcasting companies. We have the licensed patents, and in a total are 774. And as to the 4K, 8K UHD ATV, we have 17 licensors, 1 from the US and 1 from France and 3 from Korea. And we have 87 licensees, and we are still under negotiation with broadcasting companies. And the total number of the licensed patents for this 4K 8K UHD is 495. It's still growing, so I expect that sooner or later the total number would exceed 500. And remarkable thing in these license programs is the capture ratio. It's almost 100%. It means that almost all of the implementers in the market are licensed. And as I mentioned, it's very unique in our license that we license to both receiving device and broadcasting services. We license only standard essential patents evaluated by a neutral third party. That is Japan Intellectual Property Arbitration Center. And Japan Intellectual Property Arbitration Center checks the essentiality of all of our licensed patents, and only the essential patent confirmed essential are licensed as a licensed patents. Of course, the conditions are planned, and the potential licensees and potential licensee are entitled to choose an individual license rather than the license through the largest patent pool. Then I'd like to talk about how to get licensors and licensees. As to the licensors, it was very important to persuade NHK, as I mentioned, the Japanese public broadcasting company, and who contributed to standardization and was promoting digital television and owns valuable essential patents. And as a result of the negotiation with NHK, they finally agreed to take a license through the patent pool, I think in view of its efficiency. And we also contacted the foreign patent holders individually, and they also agreed to license through the patent pool in view of the efficiency, and they recognize the high capture ratio. And also, we stressed the merit to license the broadcasting services in view of the fairness for the implementers. As for the licensees, first, we captured major C companies and NHK, who are also the patent holders. And the important thing is that all of these companies who owns the essential patent also take a license as a licensee and pay certain royalties with the same conditions as the other licensees. And the conditions from, I think that the licensee recognize the efficiency to take a license from our patent program. And I will explain in more details about the negotiations with broadcasting companies. And one more thing I'd like to stress is we are promoting the activities in a relevant market to increase the recognition of our activities. So I will explain how to persuade the broadcasting companies to take a license. As you can imagine, most of the broadcasting companies took the position that license should be made to the broadcasting equipment rather than the broadcasting services. So before starting negotiation with broadcasting companies, we confirmed to the patent holders and checked if there was anyone who licensed their patents to the broadcasting equipment. And it's confirmed that no patent holder are licensed to the broadcasting equipment. So under the circumstances, we stressed and negotiated with broadcasting companies, and essential patent licensed in our program were implemented as broadcasting systems, and not within a single unit of the broadcasting equipment. So the broadcasting companies, as a user of the broadcasting system, should take a license. And since no patent holders grant a license to the broadcasting equipment, there's no double license or no exhaustion. In this sense, I think that there are some similarities with the license to the end products. I will mention this later. So Next, I'd like to speak about license for service for IoT. This chart shows license status in the contents delivery system and their reproduction or receiving device. As you know, in the past, contents was delivered on the media. The data and the information contents are stored on the packaged media. And the license covers not only device, but also the media. And as to the ABC and digital TV in Japan, at least, the license covers device and the broadcasting services or broadcasting system. So how about communication or IoT related technologies? I think that the devices are licensed already, but I'm not sure if transmission services are licensed in these communication and IoT technologies. So as an example, let's study the license status for connected car. As you might know, the reasonableness of license to the end products was affirmed in these. One is a lawsuit against Daimler by Nokia in Mannheim, and also the business review letter for 5G patent pool managed by Avanci. Is it possible to license the transmission services? The possibility to license to the base station operating entities or service providers. I think that it's possible because they are using patents, the integration of the technologies for transmission of the services. And how about other IoT-related industries? Robotics, industrial automation, medical, smart home, etc. Is it reasonable to charge royalties to receiving device only? Is there any possibility to license to transmission services? I think we should seriously consider such a possibility. Here is my conclusion. It's a conclusion, but it's my proposal. We should seriously consider possible change or transformation of the old culture of our patent license, in which the device is only licensed within the ecosystem of the communication business. But rather, it's become more reasonable and appropriate that the transmission services are licensed rather than the receiving devices. The major beneficiary in the ecosystem. I would propose that set owners should change their mindset and challenge to create a new culture of the patent license to grant their patents to the transmission services. One remark here you can find is there might be a slight difference between the license to the device and the license to the services. As you know, in many cases, the license to the device, in case of the license to the device, the royalty is charged only once to such one device. But as to the license to the services. In many cases, the transmission services are made on the subscription basis. So it might be necessary to change such a licensing scheme to charge not once, but multiple times. That is just one remark, I think. So that is the end of my presentation. And if you'd like to know our activities in more details, please visit our official website written here. Thank you very much.
Thank you, Endo-san, for the interesting presentation. So, I would like to have some Q&A session, so that if there is some people that would like to, inquire anything to Mr. Endo, that would you please write down in chat or raise your hand or just speak up. So maybe that I will start from the question that I received personally. So, well, that this person say that I fully agree with your insight to shift end licensing point from product to transmission service. So that if the licensable patent doesn't cover the transmitter, how can you structure a license program? Is the question.
Okay, thank you. Good question. I think it depends upon the coverage of the standards to be licensed. But even if the patent doesn't directly cover transmission technology, it's still possible to license to the services as far as the patent covers certain portion of the process before transmission. One of the possibility would be to grant a license to the service providers have-made rights, so that such company can use such have-made rights to apply to the process before transmission of the services. And I think that if we can have the broader coverage of the standards to be licensed, it's much easier to license to the services because we can treat a number of the patents as a package. So in this sense, the patent pooling system would have the good potential rather than the individual license.
So that you can collect as many patents as possible from all the many patent owners. And that will have a good value for the licensee to obtain the license through patent pool rather than from the individual patent owners, right?
Yes, I think so.
Okay. And another question that I received, so that thank you for the interesting presentation. And do you intend to charge royalty of transmitter patent based upon value of transmitter or service fees?
Well, it depends upon the patent holders' ideas. Both would be possible, but I think at least in future, we should consider charging royalty not to the device or transmission device or equipment, but the services, service fee would be the base of the royalty to be charged. As an example, please visit our official website. For example, as I mentioned, satellite UHD TV 4K, 8K essential patent license program. We disclose our licensing conditions for the services. Under the such conditions, we charge royalty to the total revenue from the license from the transmission service, broadcasting services.
That's interesting. So now that it's 10 a.m., so that the last question. So what do you think is the major obstacle of the broadcasters obtaining 4K, 8K license, while that they took license of 2K program?
It's just their internal reasons. We entered into the license for 2K with broadcasting companies almost 3 or 5 years ago, and their management changed since then. So it's necessary for them to explain and convince their management, explain the past histories, and persuade their management to take a license for 4K and 8K again. I think that's just such an internal issue.
Okay, so that means that still in the broadcasting company, that it is not the, how to say, the mandatory or that the policy to take a license themselves. So they know that whether the education is the right word, but the broadcasters should also has to, how to say, consider to keep obtaining a license like that they did in the past, but it is still not that level.
I think that they basically agree the license is necessary, and the main part for the negotiation would be the amount of royalty. But maybe it's somehow confidential, so I cannot say in more details. But I believe that it's just the issue of the total amount.
Okay, so that's not the cultural things. So
No.
but just the financial things.
I don't think so.
Okay, thank you very much for your interesting presentation. So Neil, that and it over to you.
Okay.
Yeah, thank you. That was a great presentation.
Thank you.
And so our next speaker is Ken Adamo, and he's from the law office of KR Adamo. Ken is a very well-known litigator and is going to be giving us a little bit more insight into connected cars and some of the things that are happening on that front. So I will get the screen up here. And then Ken, you're all set.
Okay, very good.
Yeah.
Thank you. I'm being lazy this evening. Neil is going to keep me from being distracted by being my director here. Konbanwa to my colleagues in Japan. Good evening to the rest of you around the planet who boringly only speak English. Let's talk about connected cars, SEP level of licensing. 2, Neil. First slide actually is needs a lot of amendment because there's been a lot of activity in this area. Connected cars SEP level of licensing relates to component versus end product. That's the level of licensing issue. And why is it important? Because the level of licensing, whether you license at the component level or the end product level, drives exhaustion. That you, once you license the technology, depending upon the level that you license it, you exhaust the patent rights and you can't be chased for infringement by someone else. This area got very active around the time of the Avanci Department of Justice Antitrust Division Business Review Letter, which actually issued late June, July of last year, just before the Ninth Circuit reversed FTC Qualcomm, which was in August of 2020. The next major event was the Continental versus Avanci case in Northern District of Texas, which was before Chief Judge Lynn, a fabulous trial judge, and just a joy to try a case in front of her. That motion to dismiss was granted in September of 2020. There's an appeal pending on the Fifth Circuit that mainly, as we'll talk about in a second, elected that when you have SEP issues, contrary to what happens in Europe, you do not look to competition related ways to solve your problems. You look at contract related ways. And that's the way the case turned out. Then in September of 2020, things really started to pick up. Out of the blue, the Department of Justice, without request and with no forewarning, issued an update to a business review letter that they had issued to the IEEE in 2015. Those of you who remember that IEEE 2015 time, that was when IEEE, in contrast to most of the rest of the SSO, SDO world, decided that component licensing was the way you should go, much to the chagrin of many other people who were involved in IEEE SEP situations, and actually led to, instead of letters agreeing to the FRAND conditions set by IEEE, you had letters coming from major patent holders refusing to honor that particular situation. So that's the way things stood in 2015. September 2020, out of the blue, the DOJ, and we'll get to this in more detail, the DOJ comes out and essentially says, no, people, you all misunderstood what we really were saying in that business review letter. We didn't really approve what IEEE had done, and you really need to go back and rethink that. December of 2020, the IEEE Board of Governors directed their subsidiary board, the Standards Association Board, to review two parts of the 2015 BRL. Now, remember, by now, an election has taken place, and we're not exactly sure what's going on in the Department of Justice, but IEEE looked at all this and said, well, maybe we better make a change. And then this week, within the last 7 days, one of the events actually took place today. We've had two more complicating things happen. On April 15th, 2021, the Department of Justice moved on their website where they had put the September 10th, 2020 update to the business review letter basically off into a corner. They took it from the place where the business review letters are found in the website and stuck it into a place that is reserved for comments to states and organizations, essentially putting this whole thing in the closet. Okay, now, of course, April 15th of 2021, the Biden administration is in place. Del Rahim, who was certainly a Trump administration person, is no longer running the Department of Justice Antitrust Division. So no one really is now sure what that September 20th update means, September 10th, 2020 update means. And then actually today, earlier today, during a IPCAT LSE, London School of Economics joint event in London, that the title of which was CJEU's billion-dollar question: who gets an SEP license and when should an injunction be granted? Just recently retired Lord Justice Sir Christopher Floyd, a Court of Appeal judge in the UK, said that the ETSI Standard Essential Patent Licensing Pledge, so this is now ETSI, not EEE, but ETSI actually entitled makers of components to license on FRAND terms, which, according to His Honor, then put ETSI and IEEE in the same place. If you don't think this is confusing, wait, it gets better. Neil, 3. Now, where this all starts actually is in 2 papers that really focuses it from May of 2020 and from June of 2020. Professor Cotter is a law professor at the University of Minnesota Law School, very well known, writes a lot in this area. He's one of George Contreras's peers. And Professor Cotter wrote an article talking about level of licensing, and he broke level of licensing down to license to all or license or access to all. And he says in the first part of this quote on slide 3, one of the most intense debates right now within the global patent community is whether owners of standard essential patents committed on FRAND terms are obligated to license their SEPs to any implementer within the supply chain, whether it be the end user or the component manufacturer. Now, this is very much supply chain driven, but what he's basically saying here is it's the actual end user or the component. If they request a license, are they entitled anywhere in the supply chain? There are 2 concepts under license to all, right? Once the manufacturer of a component obtains a license, that exhausts the rights up and down the chain. We talked about that for a moment ago. That's why level of licensing is important. That's license to all. Under access to all, the SEP owner charges the component manufacturers nothing and instead collects all its royalties from the end user. Now, interestingly, in the FTC Qualcomm case, I don't know how many of you remember all the detail, but before the trial that led to the antitrust findings from Judge Koh at the trial level, Judge Koh had granted a summary judgment motion agreeing with the FTC that component level licensing was what you were supposed to do. Now, when the Ninth Circuit reversed the antitrust part of that case, it vacated Judge Koh's grant of summary judgment in favor of license to all. It did not, however, kill it. So that particular issue in the Ninth Circuit is still alive and can still be revisited. 4, Neil? The other article that was written at about the same time by Dr. Lane Farrar and actually a person from Kirkland & Ellis comes out in exactly the opposite direction. That the article concludes that, this is from the abstract, that neither the law nor economic welfare justifies a license to all interpretation of FRAND commitments. To the contrary, such a regime is not supported by patent, contract, or antitrust law and likely would be harmful to social welfare. So obviously, huge polar opposite positions here between license to all and access to all. Lane Farrar's access to all, Cotter is license to all. 5. Okay, now we get to Avanci and the DOJ's business review letter in Avanci. Avanci is a patent pool. I'm going to assume that people understand what a patent pool is. Avanci actually was started in 2016. Originally, it focused on licensing patents that were essential to 2G, 3G, and 4G cellular technology. But as the market turned to 5G, Avanci also turned towards 5G cellular technology. So November 2019, Avanci submits a BRL request to the DOJ regarding its planned expansion into 5G automotive conductivity through a proposed joint patent licensing pool. And the deal was going to be, as part of that arrangement, Avanci would license patent claims that have been declared essential to implementing 5G cellular wireless standards for use in automobiles, and then distribute royalty income among the platform's licensors, a normal way that a platform works. 6, the BRL comes down, and then the commentators immediately read it and start telling people, oh, this is very interesting. Lawrence writes writes a very good paper where it talks about the DOJ's response to the request for the BRL, and says, quote, probably the most controversial aspect of Avanti's automotive licensing platform is that it will offer licenses only to the manufacturers of connected cars and will not offer licenses to component manufacturers higher up in the supply chain, such as those producing telematics units, the module of a connected car that will make use of 5G technology. And Lawrence says, well, the DOJ takes the view that limiting the field of use of 5G platform in this manner does not necessarily make the platform anti-competitive, meaning no antitrust issues. And it goes on to conclude that on balance, the platform is unlikely to harm competition, and DOJ has no intention of challenging the platform. So DOJ now, as far as Avanti is concerned, has come down as access to all. 7, I'll save this for you to look at later. This is a really important point that the DOJ, and this is a quote from the BRL, the DOJ wants everybody to understand that the department is making no assessment of whether end device licensing, right, licensing the vehicle versus licensing the component, the telematic components, will be successful in the industry, or whether it's the correct approach to licensing in this space. We also don't assess whether licensors shall be held liable for breaching their individual FRAND commitments if they choose not to license outside the proposed platform to suppliers. We simply say it's unlikely to harm competition. 8, another commentator right about the same time, Quinn, says one of the more useful elements of the BRL, Avanti BRL, is its explanation that the choice to license solely at one level of the value chain, end device level in Avanti's case, is a legitimate and common field of use licensing feature that's been blessed by the Antitrust Division for decades. Of course, it's been blessed by the Antitrust Division because it has the virtue of also being black letter patent law. Neil, skip 2, go to 10. Thank you. Now, the Continental versus Avanti case is a trial court level case in the District of Northern District of Texas before Chief Judge Lynn. 10 and 11 essentially summarize what was at issue in the case. Cutting to the chase, Chief Judge Lynn granted summary judgment, finding that Continental hadn't properly pled and supported a Section 1 of the Sherman Act violation, that Continental's allegations of the patent owner's agreement to pool their SCPs to license them only to the OEMs, that's the end users, under non-FRAND terms was not sufficient because the patent owners could license to non-OEMs at any price. In plain English, that means Avanti designed the pool, as often happens, where you didn't have a restriction, so you would only go to a certain group of members in the pool as far as licenses. The patent owners could independently not follow that restriction in the pool and license outside. The most important conclusion, I think, here is that Judge Lynn said that if patent owners violated FRAND obligations, the nature of such violations was a breach of contract and not a violation of the antitrust laws. You are not in Europe, you are in the United States, and we don't think competition rules should control. Neil, go to 12, so jump 2. Okay, now we're back to the DOJ 2020 rewrite of the IEEE 2015 BRL. I've more or less explained earlier what the original position was and what the end position was. So originally, IEEE in 2015 went to a license to all system. That's what Avanci refused to do. The business review letter and that had been Obama antitrust in 2015. The 2020 supplement in September told them to go back and look at it again. You got it wrong. December 2020, the IEEE board starts to go back and look at it again. And then the last week happens. So where are we? Well, the DOJ has taken the September 10th, 2020 update, which basically said IEEE got it wrong, and kicked that into a corner somewhere. And then today, you've got Lord Justice Sir Christopher Floyd noting that, as far as he can see, the ETSI, now not IEEE, but ETSI, the other major SSO, SDO that we're dealing with here, well, that licensing pledge in the ETSI agreements entitled the maker of a component to license on the FRAND terms. Last very interesting point. A number of people, all of whom were speaking under Chatham House rules, okay, and personal views only, besides his lordship, a number of people also were there. One of these people said, well, my company grants SEP licenses at component level. I'm not going to identify the company because identifying the company would identify the speaker, and that violates the Chatham House rules. But you could have heard a pin drop when that statement was made. So where are we now on level of licensing? Well, a little while ago, I would have said Avanci and end product may have won the day. Right now, I'm more inclined to say that licensing anywhere in the value chain, including components, may be ahead. Interesting times, folks. Interesting times. Thanks. That's it.
Thanks very much, Ken. That was great. A really good summary of where things have been and where they're at now.
It's all changing. This rapid change. Nobody saw the September 2020 update coming from the Justice Department when Trump was still president and Del Rahim was still running the DOJ, and nobody saw this April 15th moving of that supplement into another area. Now, one thing I should have reminded everybody, the position of chief of the antitrust division in the Department of Justice is vacant right now. Del Rahim has left. We've had a change in administrations, and there's no idea who the new person in charge is going to be and what that might mean. There isn't even a name that's been circulated to identify who the new antitrust division head in the Department of Justice is. So we really are up in the air on all of this right now.
And I'm just trying to get into the chat here, because I think there may have been a question. And somehow I'm not able to see the chat. Someone else? So here we have, I guess, a question or a comment. An SEP holder has the freedom to choose at which level to license its SEPs. That's Nokia and Daimler. In the mobile industry, device level licensing has been an industry norm and has efficiencies, FTC and Qualcomm. I think that's probably a pretty good summary as well.
Well, I don't disagree with that summary, but I disagree with whether the prior cases that like Nokia versus Daimler, which is a German case, which is rather up in the air. Remember the CJEU, which this panel was directed to this morning was all about a CJEU set of questions that came from, I'm pretty sure it's Nokia Daimler, that case, to the CJEU. And one of the questions is who gets an SEP license and at what level? And the questions go to component versus end product. And they also raise questions about whether there should be injunction possibilities in SEP. So Nokia Daimler is in the wind right now as a view of that referral. And the mobile industry, device licensing has been an industry norm and has efficiencies. Well, that's absolutely true as far as FTC Qualcomm is concerned, analyzing it from an antitrust standpoint. But remember the summary judgment motion where Judge Koh said, no, 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 you've got a license at the component level. Yes, it was vacated, but it wasn't knocked out. So that issue is still a live issue. FTC versus Qualcomm did not decide that. It reversed. So there is no rule on it right now. They reversed what she said, but it didn't knock it out. So I agree that these two positions are right at a certain time. I don't think, though, I would want to bet that they're right today and tomorrow. That's my point.
Yeah, a lot of balls in the air at this point, I think.
That's exactly my point.
Yeah. We have another comment here. Patrick, did you want to turn on your mic? And
Yeah, sure. So Ken, two questions really. Lena Khan's name has been floated as a possible nominee for DOJ Antitrust Division. She was very involved in Cicilline's probe, I'll call it a probe, report last year about tech. If she's appointed or someone with her leanings are appointed, don't you expect DOJ to be more aggressively involved?
You know more about her, Pat, than I do. I've heard the name, but I didn't think that she was really out there as a lead candidate. But in view of what you just identified as some of the projects she's worked on, the Madison theory that Del Rahim was pushing, I would agree with you. It may not survive. I think that's very possible.
Just one other quick follow-up, Neil. I mean, Ken, the other thing that I'm concerned about, I mean, you and I have both been doing this stuff at the interface of antitrust and patent law for 40 years. And most of that time, it's been pretty stable. It's looking pretty unsettled right now with one administration flipping one way, the potential, given the noise on the Hill right now, of the current administration flipping very strongly the other way. I mean, I'm just concerned, I'm interested in your views. I'm just concerned for the business community. It's not giving them clear guidance for licensing programs that are going to be in place 10, 15, 20 years.
I couldn't agree with you more. And worse, Pat, as you and I know, not only have we got DOJ antitrust sort of in the wind, where the FTC is these days, it's not very clear. And we don't have a fearless leader of the United States Patent and Trademark Office right now, because Andrei Iancu has gone back to his firm as is traditional. And I don't think we've even got a clear name for who the possibilities would be for the US PTO. So we've got FTC, DOJ, and the USPTO all kind of going like this. And I can imagine the business community in the United States is not very happy about all that. I agree with you completely.
thanks very much, guys. I appreciate the presentation, very good, and the questions as well. Thank you. We should keep moving though. And so I'll turn it over to Tomoko-san to introduce the next speaker. Thank you.
Yeah, thank you. And thank you, Ken, for the very interesting, informative presentation. It was really, how to say, the help to understand the situation regarding the step licensing. So that we will move to the last session today. So the last speaker of today's session is Mr. Tomohiro Nakamura. So Mr. Nakamura, after graduate that he joined Toyota Motor Corporation in 1984. And at Toyota, he had dedicated globally trademarks and designed practices to protect and enforce the trademarks Toyota or Lexus, maybe everybody knows, or there are quite a lot of trademarks in Toyota. And with the practice as such, the Tom had been much involved in activities at Japan Intellectual Property Association called JIPA and the Japan Automotive Association, JAMA. So that at JAMA, the Tom had led other car manufacturers to organize an enforcement team to crack down the counterfeit in other jurisdictions. And in 1990, Tom was admitted as attorney and started his own firm, Konishi and Nakamura, in 2001. So the Tom continues working for trademarks and design practice, where recently intervening negotiations for internal clients in terms of trademarks. So today that he will give us the new design act and that some reaction from the industry as well. So Mr. Nakamura, so it's your turn.
Okay, thank you, Noguchi-san. So, can you hear my slides? Okay.
I can see you, but it's still at the small size.
One
So
side.
if it is possible, that is to make it a little bit bigger.
Okay. Just
Smaller.
I should and see small.
Well,
we're not
we
seeing the
can
slideshow
see
yet.
it, but if you can change to the slideshow mode, that should be better.
Okay, I will just go.
And if it is difficult, just go ahead.
Okay.
Oh, now we see you.
This is slideshow. Right?
So
Let's say, okay. How about that?
still waiting. So Neil, can you see the slide?
No, not yet. I can show them from my side.
Okay, please.
I think that should be up now.
Okay, thank you, Neil. Okay, shall I go? So thank you everyone for coming today. So my name is Tom Nakamura, Konnichiwa Nakamura. I'm just to speak from Nagoya, Japan, Central Japan. And first of all, I'd like to say thank you for LES Japan and also AIPLA board meeting board members, because the three speakers actually deal with the a matter of license, but my speech doesn't refer to any license. It is unrelated to license. It's a pure instrument to protect the intellectual property, so patent, trademark, and design. So it's different from the. So let me put aside the license, but I'd like to speak about the new Design Act in Japan, which implemented in 2020. So now you can be laid back, because my slide, unfortunately, does not have the much text. Rather than you have a good amount of the pictures, so picture has 1,000 words. So I prefer to use a lot of pictures just to show you the what's up in the new law in Design Act 2020. Okay, next slide, please. Okay, I'd like to mention the 2 points. So a key point, widen scope of the protective design in the new law, and also useful amendments in practices. So it is really comparable to the US design patent and quite different, but you should be aware that the practice sits in the new law in Japan, please. And widen scope of protective design. So you see the 3 new design can be protectable under the new law. So one is the graphical user interface, GUI, and building. Building external design, also internal design both. And also interior, design of interior, housing and offices and something like that. So you see that GUI and building and interior, all of them can be registerable under the new design law in Japan. Next, please. You see the statistics. 1 year has passed since the implement of the new law. You have a good amount of number of the filing in a year. So regarding the GUI, you have around 1,000, and the design filing about the building 360, and also design of interior, you have the 235. In total, 1,600. I think it's a good number after implement of the new law. And already pendency in Japan about design filing is around 6 months. So you have somebody already get registration regarding the GUI and building and also interior. So you have very good example in the future practices about design practice, design protection in Japan. Next, please. This is the first GUI registered under the new law. This is not design of the motorcycle, but it was registered design for the GUI. You see, this design actually projected on the surface on the road. So this GUI show your presence on the road. So such as GUI are just registerable without identify any article and product. So you don't need to identify the product to register GUI design in Japan. Next, please. This is the also registered GUI design. This is very important for everybody right now. So rather than my speeches, so GUI just used for guiding proper way of hand wash and hand wash guidance. This is registered design in Japan. So this is the also you can project on the mirror on some other screen on the wall wrap or something like that. So this is also registered design GUI. Next, please. You see just a simple icon, pen picture and INK ink. And this is not trademark, but registered design under the new law. And this is the icon. You can register trademark as well, but somebody registered this mark as a design. You should be aware of the description of GUI. When you want to register a GUI design, you are required to identify description of GUI. It is mandatory under the new law. It is said the GUI is used to log in computer software that store a writing pressure and picture image and a stroke, order, etc., which have been used in handwriting. So this is not simple design, but also the design which could functionizing the software. This is the requirement under the new law. So you should be aware that it's really quite patent claiming. So it's compatible in Japan from patent to design. You can convert in some time. Next, please. GUI, it's quite interesting to register in Japan, and it's very effective. So, but you should be aware that you're required 2 points to register GUI. So GUI have to be used to perform some functions or some task. Or GUI can display a certain condition and operating ongoing. They are required to register the GUI design right. Unfortunately, icon is just the ornament purposes, and it does not have any function and linkage and any interplay with the software, you can register GUI as a design right. So it could be fall in under the umbrella of the copyright law. So this is the requirement under the Japanese Design Act, so quite different from the US design patents. Next, please. This is the first registered design of building, part of building. This is the commercial complex. Maybe the downfield. Somebody built up the complex commercial building. This was registered by first detailing in the operating company of the Uniqlo in Japan, very famous company. Next, please. This is the also registered design of the station, railroad station in Tokyo. And this is the partial design, not entire pure. This is the whole design. You see, so registered actually claim the design is the solid line. So dotted line was disclaimed. Next, please. You see the condominium. And condominium, now you can register condominium design in Japan. So this condominium has two colors, blue and gray. Registrant disclaim the part of the design in blue. They just claim only the part of the gray. So this is emergency and upstairs. And you see that right side, this is the design, partial design of building, that is offices layout. You can register all such a layout under the new law in Japan. Next, please. This is the also design of interior, number one registered in Japan. This is you see the gray part and not gray part. So the registrant actually disclaim design in gray, but rather than they claim the protection for the white. So bookshelf and roof design somewhere and desk. This is the part of partial design. Next, please. This is very unique. This is the part of the interior design. So kind of the refrigerator. There display on top of the refrigerator. So this is the part of the design, but it can fall in the design for interior of supermarkets. Next, please. Now, you see the various example actually registered under the new design law. Now I'm going to mention that other useful amendments in the new law. Something look like similar to the US practices, but others are not. So I want to mention that related design and the term of protections and the Hague international application and the contributory infringement. Next, please. Related design. In practices, it looks like the continuation practices in the patent prosecution in the US, but different, substantively different. So could you please next? Next, please. So this is the very unique system, and I think you don't see such a system other than Japan. In other jurisdictions, they don't have this related design system. So let me simplify the system. Let me simplify mechanism of the related design. So you see the mother design, and also you created the similar design, either child design, and also grandchild, and also created grandchild. So, but as long as our filer of design is the same company, same entity, you can continue filing the similar design in 10 years from date of the filing date of mother design. So this is the kind of the exemption of novelty and the first issue principle. You should be aware key point when you want to use data design. One is similar to former design, and unfortunately, even you file the child design and granted design, child design cannot maintain the same filing date, not exemption of the filing date. And also, this is the one of the biggest advantage by using the data design, exempt lack of novelty and the first file and the first register within 10 years from date of mother design. And the term of protection synchronize term of the mother design. So even you have the grandchild design, but right over design is synchronized with mother design. This is very important issue. Next, please. Term of protection. Next, please. Fortunately, term of design protection in Japan longer than it used to be. Now you have the 25 years, so long from filing date. Used to be you can only have the 20 years from date of the issuing date of registration, but now you have 25 years. It means longer than patents, longer than patent right. Patent is 20 years from filing date in Japan, 25 years for design protection. It could be comparable to the US. In the US, only the 15 years from issuing date, and European Community, 25 years. And China, it has the new Patent Act, which implemented June 1st. You can get 15 years from filing issuing date. So now Japan is the longest country, longest jurisdiction. You have the 25 years for design protection. Next slide, please. Now, the Hague. Somebody aware that Hague is the international PCT in the design protection. Japan became a member state in 2015. So you can use the Hague system when your client prefer to protect the design in Japan. It's quite easy and cost effective. Next, please. And this is the number of filings to the international WIPO in Switzerland. And it is not a good amount, actually. So you see that in the bar in 2020, you have around 30,000 in Japan filing number of design, but only 3,000 design actually came from the international WIPO in Switzerland. Not a good amount, but the number is a little bit growing. So this is very effective in Japan. And also, again, you can get pendency in design filing in just 6 months, quickly than patent. Next, please. This is the number of the Hague application. You see the bar graph left side. This is the number of the applicants. US company actually filed the design patent in Japan, and some part of the US entity rely on the Hague system. And also you see that from US, Japan Patent Office has the 2,300 filing, and the number of international come from the around 2,000. So good number. Next, please. Finally, I'd like to mention that contributory infringements. It's somehow unique in our jurisdictions. Please. This is very good commercial success and hand-face massage in Japan. And this was registered as design. Next, please. But you can find 1,000 counterfeit in Amazon and Rakuten or other web e-commerce and the markets. So if you find the counterfeit hand massage, how you can protect in Japan. So you can insist that direct infringement if you find the assembler and manufacturer of the whole part of registered design. But counterfeiter is very smart, as you know. So the supplier X are just exclusively selling and manufacturing the part of the massagers, kind of the above. And supplier X is responsible for the manufacturing, just the handle. So each supplier has own role. They never make assembling products by themselves. So, but in that cases, under certain circumstances, you can insist, you can enforce your design right based on the contributory infringement. So one is the requirement is that design of parts forms an I appeal in the registered design, and a supplier X or Y is aware that a part is supposedly used to assemble the registered design of the entire product. So if the requirements are met, you can insist infringement like the contributory infringement. That's a very unique enforcement instrument under the new design law. Next, please. So that is I use design protection in Japan. Thank you.
Thank you, Mr. Nakamura, of the very interesting presentation. And you know that I have this message.
Exactly. It is
Yes.
the system design.
Yeah, actually, this is very important because especially for women, such kind of product is really necessary to reliable one. Otherwise, that it will affect the skin because that it touches directly to skin. So that as Mr. Nakamura mentioned, that there is quite a lot of fake products everywhere. So that I hope this new design protection helps the consumer to get some harm from the fake product. I'm really happy to see it that if it's much easier now to have some the infringement act. So I like it.
Yeah.
Yeah.
Thank you very much for the presentation.
And is there anybody that who would like to have question? That actually that this is 10:50 in Japan, so that if there is some other question that we can take one, or that if it's okay that I would like to ask you one question, just that you mentioned that we can have the continued registration, the related design that you say, and that after filing the murder product, that you can file the child and the grandchildren. But what happened that if the similar product like that with the design of the child product is already in the market before the owner of the design of the murder product still doesn't file the design of the child product. That what happens to the mother, and that someone starting selling the child product, and that the original owner tries to file the child product as related to design. That what happened in such case?
Okay, Nomoshi-san, thank you. Very good. Very good question, and it's very important in practices. So it could be happen in actually. So this is the point of arguable. In principle, if there is the design actually disclosed third party, which is similar to related design, you cannot get registered child design because already somebody disclosed your similar design in the market. But in some cases, a design disclosure by third party could be counterfeit, fake, copycat. In that cases, a latest discussion at the JPO says that it doesn't, no worry. You can get related design as long as you prove that design disclosure is a counterfeit, not the real product. So you can get under certain circumstances, but in principle, you cannot get registered. So already design is lack of novelty, except for it could be counterfeit.
Okay, that is very interesting. Yeah, thank you very much. So if there is no further question from audience, so that Neil, do we move to the closing remark?
Yeah, I just wanted to mention that we will be having a networking session right after. And so we are going to take the group and divide into smaller rooms for informal discussion. So I hope everybody can stay around. And maybe just wanted to say thank you to all the speakers again for the time and effort put into being ready for tonight. That was great.
Yeah, thank you from me too, that this was very informative and it's very good presentation, and that I'm very happy, and this is really great that I can concentrate even more than the real play. Real place. But anyhow, so that I would like to, how to say, ask Mr. Makoto Ogino, the former president of LAS Japan, for closing remarks. Mr. Ogino, are you there?
Yes, I'm here. Thank you, Tomoko-san. My name is Makoto Ogino, the immediate past president of LES Japan. I'm sorry, I'm wearing a face mask. I'm sorry. But first of all, I'd like to thank the speakers of both AIPLA and LESJ for their wonderful presentation. I think all of us have been able to update our knowledge on the current IP and licensing issues in the US and Japan. Also, I'd like to thank those people of AIPLA and LESJ, including Neil-san and Tomoko-san, who have prepared for this virtual joint meeting with great efforts. Without their great efforts, this joint meeting obviously would have not been possible. I am very happy that this year we are able to have the meeting despite the COVID situation, thanks to the online technology. And as all of us see now, the meeting is quite successful. I sincerely hope that next year we will have a face-to-face meeting, perhaps without the help of online technology, having overcome the COVID-19. Thank you very much, and see you next year in Tokyo, face-to-face. Thank you.
Thank you, Ogino-san. So, Neil,
Yeah, and for closing remarks from the AIPLA side, I'll call on Ann Muting, who is the second vice president of AIPLA, and turn it over to you, Ann. Thank you.
Thanks, Neil. And on behalf of AIPLA, I too want to thank all the speakers and the organizers for this great joint meeting. The presentations were very informative and very much appreciated. And I know I can speak on behalf of everyone at AIPLA that we look forward to getting back to in-person meetings, and in particular to the 2022 trip to Japan. I'm going to say that positively. We are going to Japan in 2022. We're going to be past this, and we will be there for this particular meeting. And I personally look forward to meeting everyone on this, on the LES side of Japan's organization in person. And again, thank you on behalf of AIPLA for these continuing to have these presentations, even in these difficult times, and these joint meetings, even in these difficult times. So thank you very much.
Thank you, Ann. So I think the next step is that we will stop the recording, and then we will move to the breakout rooms. So just hang on a sec. I will stop the